In charge of chairing the last session of this conference. First of all, I want to thank the organizers and in particular Professor Gemma Andreone for the invitation to participate in this conference. And my task is quite simple, just to direct the traffic of the speakers and also to make some reasonable, hopefully, conclusions at the end of the meeting. So my request to the speakers is to limit their speeches to 15 minutes in order to leave some time also for the discussion. So the first speaker on my list is Professor Roberto Virzo. He is Professor of International Law in two Italian universities, Messina and Lewis here in Rome. Incidentally, Italy is planning the construction of a bridge across the Strait of Messina, but this is another question. And he is also the legal advisor of the Ministry of Foreign Affairs in Italy, and he participated in the discussion on the advisory opinion of UNCLOS on climate change, expressing the Italian position. The subject of his intervention is protecting the marine environment, UNCLOS and the interpretative criterion of systemic integration. Please, Professor Virzo.
Doesn't work. I open it, but it doesn't work. Okay. Let's see. Yes. Thank you very much. I would like to thank Gemma Andreoni for her kind invitation to this important conference. So I'm very pleased to be here with you and to discuss about a technical issue. I hope not to be very boring, considering that we are after lunch. So I hope everything will be fine with you, even if we are going to speak about systemic integration and other criteria to apply the United Nations Convention on the Law of the Sea together with other treaties or rules of international law. So this is my goal today, to discuss with you about the systemic integration. Let me start with the advisory opinion of the International Court of Justice of last July. Yesterday, both Professor Gauthier and Professor Caracciolo highlighted the importance of a systemic integration and the coordination between treaties relevant to the parties. In the advisory opinion of the ICJ in 2025, the ICJ highlighted the importance to make a joint application of the United Nations Convention with the Law of the Sea with the other treaties. To be honest, the ICJ said that in implementing the United Nations Convention for the Law of the Sea, states parties had to take into account also other treaties, including, for example, treaties concerning climate change, and vice versa. So this was the idea of the International Court of Justice. 1 year before, the International Tribunal for the Law of the Sea also highlighted this point in the advisory opinion. And according to the International Tribunal for the Law of the Sea, we can have three mechanisms concerning the relationship between the United Nations Convention, the UNCLOS, and other treaties and relevant rules of international law. Let me say one point before going into detail of these three mechanisms considered by the International Tribunal for the Law of the Sea. First of all, that according to Article 293 of the United Nations Convention for the Law of the Sea, a court or tribunal which has jurisdiction under the convention can apply the convention and other international rules, other rules of international law, which are compatible with the UNCLOS itself. So we have two possibilities for these tribunals. The first one is to apply UNCLOS itself. The other one is to apply external rules of the external rules in comparison to the United Nations Convention for the Law of the Sea. Some scholars say that Article 293 is an article which can be qualified as an article that is based on the idea of systemic integration. I don't share this point of view. I mean that Article 293 of the United Nations Convention for the Law of the Sea can be used for systemic integration, but it's not an article in itself which is based on systemic integration. It is open to systemic integration, but it's not an article focused on systemic integration, because we have to take two different cases. The one is when we apply the United Nations Convention for the Law of the Sea. The other one is when we apply the external rules to the UNCLOS. The advisory opinion took into consideration three mechanisms in order to establish the relationship between the UNCLOS and other international treaties. In the advisory opinion, the tribunal started with rules of references, then Article 237, and finally the systemic integration. So the order given by the International Tribunal is different to the one which I decided to use for this PowerPoint presentation. Why I'm starting with systemic integration? I'm starting with systemic integration because in the case of systemic integration, the one which is under Article 31, paragraph 3C of the Vienna Convention on the Law of Treaties, in this case, the case of the systemic integration, the threshold is not so high, it's not particularly high. Why? Because at the end of the day, we have to apply the treaty which must be interpreted. In the case of the systemic integration, a court or tribunal or a contracting party of a treaty is asked to interpret the treaty, take into account any relevant rule of international law. But ultimately, the tribunal or the contracting party is not required to apply the external rule. It's required to apply the treaty, taking into account the external rule. So I will start with the systemic integration because, in my opinion, the threshold for the use of this criteria is not particularly high. Let's focus on two cases among the a lot of cases where, of course, systemic integration has been applied. Because of the fact that this conference is based on the protection of marine environment, I selected two cases which are related to the protection of marine environment. In the case of the arbitral tribunal in the South China Sea, there was a problem in a certain moment concerning Article 194, paragraph 5 of the Convention, which is based on the protection of a fragile ecosystem. Now, the point was that in the 1982 Convention, also because of the time when the Convention had been adopted, there is no definition of ecosystem. So, the Arbitral Tribunal decided to use the definition contained in the Convention of Biodiversity and Biological Diversity. So, in order to give a definition of ecosystem, the tribunal, and the same did 1 year ago, the UNCLOS in the advisory opinion, they decided to interpret Article 194. So, at the end of the day, it was the interpretation and the application of Article 194 using external rules. So, a treaty or a different rule which was relevant for the interpretation and then the application of the United Nations Convention for the Law of the Sea. The same was for this advisory opinion, the first advisory opinion of the tribunal. This is very interesting for several reasons. This was the case of the seabed dispute chamber for the responsibility and obligation of states with respect to the activities in the area. And in that case, the International Tribunal for the Law of the Sea, the seabed dispute chamber, was asked also to give an interpretation of a regulation adopted by the International Seabed Authority, where there was the application of the precautionary approach. If we give a look to this paragraph of the advisory opinion, the seabed dispute chamber used several external rules. It started with the Rio Declaration, of course, then the other treaties based on the precautionary approach according to the Rio Declaration, then the ICJ judgment of 1 year before in the case of pulp mill. And then it said, okay, the precautionary approach, there is a trend which says that maybe there will be a new customary international rules concerning a precautionary approach. In any case, we can apply precautionary approach based also on Article 31 of the Vienna Convention on the Law of the Sea, Vienna Convention on the Law of Treaties, concerning the systemic integration, so this criteria. But once again, if we continue reading the advisory opinion of the seabed dispute chamber, the precautionary approach was applied because of the fact that there was a regulation of the International Seabed Authority which quoted the precautionary approach. So once again, in the case of systemic integration, the point is that the threshold is not particularly high because let me repeat this point, ultimately we apply the convention, we apply the treaty that we are going to give an interpretation. So it's not a way to apply an external rule in the case of, it's to apply the treaty taking into account external rules. The only requirement is that there is a double relevance. Relevance ratione materie, of course, we cannot take from the external rules any rule, but some rule which is related to the article or the treaty that we have to give an interpretation, first point. And second point must be related ratione persone, because must be, according to Article 31 of the Vienna Convention on the Law of the Treaties, it must be relevant in the relationship between the parties. So these are the two requirements for the systemic integration. Now let's focus on the second issue, which is Article 237. The tribunal, as I told you at the beginning of this presentation, quoted three cases, systemic integration, Article 237, and clauses of reference. Article 237, now we are in a different situation. According to this article, we have not to apply the convention, but to apply a different obligation arising from another treaty. If we look at Article 237, this was also one point which was discussed during the proceedings before the International Tribunal for the Law of the Sea. This was indeed one of the positions of the Italian government concerning Article 237. The point is that Article 237 is very interesting because it establishes, it's a coordination clause. Let's start with what is Article 237. It's a coordination clause, but there is, first of all, a difference between coordination clauses under Article 30 of the Vienna Convention, because in the Vienna Convention in Article 30 we have also coordination clause, but in the case of the coordination clauses under Article 30, the coordination clauses say that one treaty prevails over the other. But this is the aim of the coordination clauses under Article 30. In this case, in the case of Article 237 of the UNCLOS, we have not this solution. The UNCLOS does not prevail over the external treaty, and vice versa, the external treaty does not prevail over UNCLOS. What does Article 237 want? Is just to have a dual relation of compatibility. Indeed, state parties can apply, so it's without prejudice, can apply a specific obligation concerning the protection of marine environment arising from a different treaty, a treaty which can be also in furtherance, as Article 237 says, of the Convention. So this is a possibility. Instead of applying the Convention, I can apply a specific obligation arising from a different treaty. So this is a different situation when I'm going to applying directly the Convention, taking into account a different treaty. But Article 237 says that we have a dual relation of compatibility, in my opinion. So according to Article 237, okay, you can apply the different rule, but the application of the different rule must be done in a manner consistent with the United Nations Convention for the Law of the Sea. So, in this case, UNCLOS must be compatible with the external treaty, and the external treaty must be compatible with the United Nations Convention for the Law of the Sea. And here we have, in my opinion, the second part of Article 293, because the Article 293 says we can apply the Convention or any external international rule compatible with the United Nations Convention for the Law of the Sea. This is a situation. Third situation are clauses of references, so rules of references. Now I will use what the International Tribunal for the Law of the Sea said. There are several, in the advisory opinion, there are several examples of clauses of references. And indeed, the United Nations Convention for the Law of the Sea is characterized by a variety of clauses of rules of references. So maybe for next scholars, a good subject for a PhD thesis could be, for example, to study the variety of clauses of references in the United Nations Convention for the Law of the Sea, because there are a lot of typologies of rules of references. Focusing on the ones which can be used for the protection of marine environment, which is the topic of our conference. For example, let's focus on Article 207 of the United Nations Convention for the Law of the Sea. Here, states are required to adopt laws and regulations, in this case concerning land-based pollution, to fight against land-based pollution. It is interesting to say that the tribunal highlighted that states are required means that states have an obligation to do so. So there is an obligation for a contracting party to convention to adopt laws and regulations. But what is the content of the law and regulations adopted under Article, for example, 207 of the Convention? Here we have a clause of reference, a rule of reference, because Article 207 says that these laws must be adopted taking into account internationally agreed rules. So Article 207 is like in the case of conflict of laws, the states adopt a law, but opening to external rules. They have to take into account that here the tribunal said that, for example, in the case of land-based pollution, law and regulation must take into account the Paris Agreement and the UNFCCC, for example. Where is the compatibility? The point of the compatibility I highlighted at the beginning of this presentation is because, according to the United Nations Convention for the Law of the Sea, needless to say, honestly, the laws and regulations must be consistent with the Convention. A state cannot adopt a law and regulation under the Convention in a way which is not consistent with. So even if the Article 207 says that you can adopt law, you must adopt laws and regulations which can take into account external rules, at the end we have the guarantee of the compatibility because of the fact that the laws and regulations which are adopted under UNCLOS take into account external rules must be consistent with the United Nations Convention for the Law of the Sea. So we have three different mechanisms, as we have said, but at the end of the day, what is, just to have a general view from this point of view? First of all, once again, maybe I can say in French, not to say, needless to say, let's say in French, just to change, ça va sans dire. The point is that the United Nations Convention for the Law of the Sea is a no-static treaty. It's a treaty, the International Tribunal for the Law of the Sea, the ICJ said this several times, is a kind of treaty which is open to new values, to the evolution of international law. So systemic integration and the other criteria work also in a diachronic way. It's a kind of evolutive interpretation and evolutive application of a non-static treaty. And this is the first point. The convention is at the same time, several times we have read this point, a constitution for the ocean. At the beginning it was a constitution maybe not from a legal point of view, but over the years we can say that the convention is a kind of constitution, and a constitution of what? Of the legal order for the seas and the oceans established by the convention itself. And in this legal order for the seas and the oceans, which is a legal order which takes into account the evolution of new values, the evolution of the international community, the Constitution is central and must be supplemented and integrated by the external rules which are compatible with the Convention itself. I apologize to have discussed about these technical issues after lunch, so I hope that you can forgive me for this topic, and thank you very much for your patience.
We thank
I don't know what I have to do, so
We thank Professor Virzo for his intervention. The discussion on his subject is reserved for the end of the meeting. So I move to the next speaker, who is Professor Guillaume Le Floch. He is a professor at the University of Rennes, France. He is the author of many publications in the field of international law of the sea, of human rights, of settlement of disputes. He is the Secretary General of the French Society of International Law and the Director of the Institute of Public Law and Political Science. The subject of his intervention is the exploitation of the area, opportunity or threat in terms of climate change and biodiversity loss, ? And I hope that we could delete the question mark after your intervention.
Okay, it's working. It's okay? Okay, perfect. Thank you very much, Mr. President. First of all, I would like to thank the organizer of these wonderful scientific events, and in particular, Gemma Andreone. I am delighted to be in Rome. This organization is absolutely perfect. You know, I have a strong French accent. The exploitation of the area is an issue that has seen many twists and turns over the last decades. It had been known since the second half of the 19th century that polymetallic nodules exist in the area, nodules that contain a wide variety of metals, including, as you can see, manganese, iron, copper, nickel, cobalt, and aluminium. However, despite technological advances, these resources have long appeared inaccessible and very costly to exploit. The situation really changed in the last decades. During this period, decisive technological advances were made in the field of deep sea resource extraction and processing. In addition, global demand for mineral has skyrocketed due in particular to the ongoing industrialization of developing countries, but also the rise of transition industries. Low carbon technologies are necessary for a successful energy transition, but they may use metals. This is particularly true for electric car batteries, wind turbines, and solar panels. Given this trend, demands for mineral is set to explode. According to the UN Trade and Development, projections indicate that by 2050, lithium demand could rise by over 1,500%. Increases should be the same for nickel, cobalt, and copper. To make the energy transition a success, we will therefore need to be able to meet this demand for minerals. Moreover, the deep-sea mining appears to be an alternative to land mines, which are often associated with geopolitical tension, human rights violation, significant environmental impact, and a concentration of supply among a few dominant countries. This is a view of a well-known Canadian company, the Metal Company, as expressed by its iconic president, Gerard Barron. According to Barron, international community will have an increasing need for metal. As a result, according to him, the international community has a choice to make. On the one hand, he can continue to exploit land mines, which result in more greenhouse gas emissions, more population displacement, more habitat destruction, and more biodiversity loss. Or, on the other hand, he can exploit the seabed, which help to meet the demand for metals and more generally achieve some of the sustainable development goals. Presenting in this way, the choice seems obvious, especially since TMC claims to be able to exploit the seabed without harming biodiversity. The metal companies therefore advocate seabed mining for a number of reasons, many of which are very noble. However, the metal company is not a philanthropic organization. Behind the deep sea mining, it naturally intends to reap financial benefits. As a result, some question the virtuous presentation made by TMC. Indeed, many NGOs dispute these versions of events. This is particularly true of Greenpeace, as you can read. The deep sea accounts for nearly 54% of the ocean surface. However, only 5% of this environment have been explored. In other words, they remain largely unknown. Nevertheless, it is established that the seabed absorbs 30% of the carbon emitted into the atmosphere. This carbon sink, which is the ocean, could be impacted by deep sea mining. Mining activity could indeed release CO2 sequestered in sediment and limit the ocean carbon storage capacity. Last June, a scientific committee made up of 17 international experts issued a scientific proclamation on mining. It stated, without the deep sea unseen contribution, life as we know it could not endure. While it may offer additional mineral resources, deep sea mining risks triggering a crisis of its own, making by damaging global ocean ecosystem and function, which are intrinsically linked to Earth's climate. That is why scientific committee is calling for a precautionary pause, allowing time to answer critical questions with a sound and scientific approach. As you can understand, we are facing a crucial scientific dilemma with considerable environmental, political, economic, social, and legal implications. Given my very limited scientific knowledge on this topic, I cannot comment further on this subject. However, what I do know is that a common ground must be found quickly between states. The answer must be multilateral and must come from the organization in charge of the area, the International Seabed Authority. So I would like firstly to say a few words about the role of the IEC in the deep sea mining, and secondly, I would like to mention the negotiation concerning the exploitation of the area. According to Article 136 of UNCLOS, the area and its resources are the common heritage of mankind. They must therefore be managed collectively and responsibly by the International Seabed Authority, which has an exclusive regulatory and administrative mandate on behalf of all mankind. UNCLOS and the 1994 agreement merely set out a general legal framework which the IEC must then flesh out. In other words, the International Seabed Authority must fill in the gap. It is responsible for establishing the regulation applicable to activities in the area. In order to carry out its mandate, IEC has general and binding regulatory powers. It has also the power to enter into contracts with any public or private mining company sponsored by a member state that intend to carry out exploration or exploitation of the seabed. However, the IEC role is not only to manage the area, but also to protect it. It is therefore responsible for protecting the marine environment. And limit, and its living resources from the harmful effect of exploitation of the area. That's Article 145 of UNCLOS. To this end, he has the power to promote and encourage marine scientific research. Since its establishment, the IEC has made a number of advances in terms of regulation. In particular, the IEC has published 3 regulations concerning exploration in the area. IEC has been able to incorporate provisions relating to environmental protection into its regulation. In general, IEC works to improve knowledge of the seabed. Based on this regulation, IEC has issued 31 exploration contracts for seabed mineral resources to parties to the UNCLOS, allowing eligible entities to conduct exploration activities in the area. However, in order to move on the exploitation phase, a mining code must be adopted. The IEC has been working on this officially since 2011. Also, discussion only really began in 2014. However, the task is far from straightforward. The international community remains sharply divided on deep sea mining regulation. On the one hand, 40 states, including European states, France, Germany, Romania, for example, Pacific Island states and other states, as well as numerous NGOs, international organizations, are calling for a moratorium or a precautionary pause, even a ban. They fear that this industry could lead to a catastrophic impact on climate and biodiversity. On the other hand, certain states advocate for expedited regulation adoption. This is the case of major countries like China, Russia, Japan, South Korea, but also some Pacific Island states like Nauru and Tonga. Most of them hold exploration contracts through national companies. This division between some members of the IEC is leading to tense negotiation and making it difficult to reach a consensus. The latest election of the IEC Secretary General is an illustration of this. Outgoing Secretary General Michael Lodge, who was in favor of mining, was defeated by Ms. Leticia Reis de Carvalho, an oceanographer. However, the IEC's inability to adopt a mining code works in favor of the anti-mining coalition. Delays in regulation constitute a de facto moratorium, as the absence of a code prevents the issuance of any mining permits. So some are trying to put pressure. In 2021, Nauru requested that the 2-year rule be activated. This should have led the Council to adopt a mining code within 2 years. Despite the effort of the Legal and Technical Commission, the lack of a common vision among states prevented the Council from adopting the regulation within the deadline. That's July 9, 2023. In 2024, the Mittal Company announced its intention to launch its mega deep-sea mining project in the South Pacific by 2026, with or without an ISA license. At the end of 2024, Nauru notified the ISA that NORI, Nauru Ocean Resources Incorporation, a subsidiary of TMC, that NORI would submit a work plan for mining by the end of June 2025, and that it's expected the Council to provisionally approve this application. Last March, the metal company announced that it had formally initiated a process under the US Department of Commerce to apply for exploration licenses and permits to extract mineral from the area. Despite these various pressures, ISA has still not adopted a mining code. It is true, as I said, that the situation amounts to a de facto moratorium. Nevertheless, in law, it's not a moratorium, and no decision has been taken at the universal level. We cannot be satisfied with this lack of action. A decision by the ISA is needed, otherwise, unilateralism will prevail over multilateralism. On April 24, 2025, President Trump signed an executive order to release America's offshore mineral and critical resources. With this decision, he's expanding the issuance of licenses and permits for seabed mining in areas beyond national jurisdiction. TMC, of course, welcomed this decision. Few days later, the metal company USA filed, it's a US subsidiary, filed 2 exploration license applications and a commercial mining permit for mining in the famous Clarion-Clipperton zone, a 4.5 million square kilometers area on the Pacific Ocean between Hawaii and Mexico that is very rich in nodule. If the application is approved, it would be the first time that the United States has authorized the commercial exploitation of minerals from the seabed beyond national jurisdiction. This US legislation is in direct conflict with the system established by UNCLOS and the ISA standards. The United States is not party to UNCLOS. Also, US officials have often stated that the convention largely reflects customary international law. They are not members of the ISA, but have nevertheless observer status. Since the creation of the International Seabed Authority, the US has always refrained from taking any action regarding the exploitation of the seabed. Until now, it has to leave the field open to the ISA. President Trump's executive order reverses this practice. This unilateral action by the United States has been widely condemned as a violation of international law by the Secretary General of ISA, for example, by the European Union. In other words, any unilateral attempt to appropriate mining resources from deep seabed outside of the ISA framework must be condemned. It is true that the International Seabed Authority did not allow itself to be intimidated during its last session. At the end of the last session, no agreement on a mining code was adopted. In addition, the ISA Council adopted a decision requested the Legal and Technical Commission to pay specific attention to possible cases of non-compliance with the multilateral legal framework by entities benefiting from such exploration contract. NORI, not Nauru, but NORI, is seeking to renew its exploration authorization in 2026, so next year. However, the fact remains that states must reach an agreement under the auspices of the ISA. We need robust regulation that protects the environment and guarantee procedures that are fair and transparent for all countries. The precautionary principle requires, if not a ban, at least a moratorium. It is the most reasonable option. We need to continue scientific research and find other sources of metal supplies and maybe rethinking decarbonization. But as you know, the United States is currently fighting any reference to climate change. We saw this morning what happened in the IMO. Moreover, and above all, the Trump administration no longer refers to international law. President Trump's threat must therefore be taken very, very, very seriously. The area on its resources has a common heritage of mankind. Climate change is an issue that concerns humanity. The answer to the question posed in the title of this contribution can only be multilateral. The International Seabed Authority is the perfect forum for conducting this negotiation, but they must be successful. Negotiation cannot go on indefinitely, even less slow in the current context. A glimmer of hope for anti-mining coalition may paradoxically come from TMC. Indeed, despite its claim, it's not certain that TMC has the capacity to exploit the seabed on a large scale, sine qua non condition to make benefits. Thank you.
Thank you very much. Again, a discussion on your intervention is reserved for the end of the session. So now we can move to the third speaker of this afternoon. She is Professor Chen, and she is Associate Professor at the Law School and Polar Research Center in the Ocean University of China. She is a specialist in polar law, law of the sea, and climate change, and she is also the editor of an open access journal, Marine Development. And Professor Chen will speak about integrating climate change into global ocean governance, a Chinese perspective. China is today a very important country. It is much involved in marine activities and also in the prevention of climate change. So it is very interesting for us to listen to your intervention about how these two objectives can be harmonized. Please.
Thank you, Chair, and good afternoon again. So many thanks to the invitation by Professor Gemma to come here and to share my personal thoughts towards this interesting topic, integrating climate change into global ocean governance from a Chinese perspective. Actually, I'm not representing any organization or Chinese government, only by my personal opinion here. So we already observe a trend that the close relationship between the two international legal regimes, that is the climate change law and also the law of the sea regime. So I call it as the ocean climate nexus. So an indivisible community of shared destiny. So actually the ocean plays a dual role here. The ocean is at the epicenter of the climate challenge. So it works as a victim it is the primary recipient of climate impacts, absorbing over 90% of excess heat and 25 to 30% of carbon dioxide emissions, as previous two speakers also mentioned about the role ocean played in combating climate change and leading to a warming, acidification, and deoxygenation. And the second role played by the ocean, actually, it also worked as a solution. So it is the planet's largest carbon sink and our most critical ally in mitigation. So the ocean is not just a victim, it is also a vital source of solution. So here, we face a governance challenge here. So how can we synergize a global ocean governance, usually traditionally focused on how we utilize the resources and how to protect the marine environment, with the global climate governance traditionally focused on emissions, no matter on the aspects of mitigation and adaptation. So the core thesis here, this presentation just want to explore this integration, arguing for a path that balance, but is a premier path that balance domestic action. So when I say domestic, I actually focus on China's domestic action and the legal synergy and pragmatic multilateralism. So here I use this word legitimacy that in the whole international society, we already accumulated enough international consensus on ocean as the mitigation path. So I divided as three stages. Here, the first stage is the early recognition to regard the ocean's role play in the climate governance that since the 192 UN FCCC, the ocean's role as a carbon sink was recognized from the beginning of the climate regime in Article 4.1 D here. All parties shall promote sustainable management and promote and cooperate in the conservation and enhancement of sinks and reservoirs, including biomass, forests, and oceans, as well as other territorial, coastal, and marine ecosystem. And then the ocean's role was reinforced in the Paris Agreement in the preamble part, noting the importance of ensuring the integrity of all ecosystems, including oceans, and the protection of biodiversity when taking action to address climate change. And it got the formalization within the following Conference of Party process since 2015 Paris Agreement. So, for example, in the 2019 decision of the conference parties, the paragraph, I quote the report here, paragraph 30, commended efforts to highlight the importance of the ocean, including as an integral part of the Earth's climate system, and of ensuring the integrity of ocean and coastal ecosystem in the context of climate change. And in the annual Ocean and Climate Change Dialogue, it is for the first time here. So the dialogue between ocean and climate change, under the climate change law, this international law regime, the carbon stored in mangroves, seagrass beds, and tidal marshes, collectively referred to as blue carbon, are small in global surface area, but highly carbon dense and could store around 0.5% of current global emissions. And this is a quote here in the IPCC report. And following here, for example, in the 2024 informal summary report of ocean and climate change dialogue. So after the first dialogue between since 2019, so we have continuous following and more frequent dialogue between ocean and climate. These two international legal regimes. So highlight the importance of conserving, protecting, and restoring blue carbon ecosystem to adapt climate change impacts. Maintain biodiversity resilience and protect livelihoods, providing an important space for enhanced cooperation, understanding, and building ocean-based climate action. So the ocean as a solution. So blue carbon ecosystem can capture and store carbon, and encouraged parties to include blue carbon ecosystem in their NDCs and national action plans to help meet their emission reduction targets. The recent COP 2019, so I haven't checked the most recent one in 2025, but the last one, the 2024, in Baku, showed us much more new opportunities for blue carbon trading markets. And these COPs made significant milestones in the implementation of the Article 6, the international carbon market mechanism of the Paris Agreement. Here, the Article 6 enables states to engage in voluntary cooperation to achieve their national development goals by trading carbon credits and established two main channels of transfer. For example, the Article 6.2, which allows states to trade international transfer mitigation outcomes through bilateral or multilateral agreements, and Article 16.4, the Paris Agreement credit mechanism, which is a centralized mechanism for host and buyer states to oversee the trading of carbon credits by the UNFCCC. So the establishment of this trading mechanism in Baku provides new development opportunities and implementation guarantees for future blue carbon trading, and I think is of great significance for exploring the standardized and international development path of future blue carbon trading market. So until now, last time I counted here. So 168 latest available NDCs communicated by the 195 parties to the Paris Agreement in the synthesis report, and parties continued to report ocean-based measures to demonstrate climate action. There is a picture here, but I lost in current PowerPoint, so I just explained to the picture. So of the parties that included an adaptation components in their NDCs, 31% identified ocean ecosystem as a priority sector for adaptation, and 13% have quantified targets for fisheries. And of the 21% of the parties that included information on ocean or blue carbon as a priority sector for reducing greenhouse gas emissions, 71 mentioned specific ocean-based mitigation measures. So the discussion of other mitigation solutions commonly cover a range of economic sectors, including shipping, ocean-based renewable energy, and aquaculture, carbon storage, as well as geoengineering type approaches such as iron fertilization, so also included in the related analysis. So in Chinese language, so in the domestic law and policy part, China already issued national policy and legislations towards to the blue carbon. So, but I know in the English articles and literatures, so the ocean-based CDR. So I have to admit, so when I check the policy and national policy and legislation in China's dialogue, so there is some confused understanding between the blue carbon and the ocean-based CDR. So we usually use a much vague language, so more general context of blue carbon in Chinese language and include the several ocean-based CDR. So here, I find a governance gap here. So there is no single dedicated. So we already talked about the ocean could be regarded as the solution for combating climate change, but there is no single dedicated international treaty for ocean carbon sinks or ocean-based carbon dioxide removal. So the governments worked via a patchwork of regimes. So the UNFCCC, the whole climate change law regime, including the Paris Agreement. Surely it is the primary regime for climate goals and reporting. And then the UNCLOS, it is the constitution for the oceans governing all activities and this clause, this part, the marine scientific research, the pollution, the marine pollution, and the navigation, all relating to the blue carbon activities. And the London Convention and London Protocol, so it is also a very plenty of existing literature, and we already talked about it more than 10 years ago. So the primary regime regulating marine dumping and by extension the marine geoengineering. For example, we have, I think in recent years, we have much more scientific outcomes, scientific evidence, scientific experiments towards to the ocean alkalinity enhancement, the iron fertilization, and this kind of scientific results not just exist in the imagination, but already in some nation and regions already going to the aspects of practitioner. And the following the BBNJ, this is the new critical instrument for governing areas beyond national jurisdiction. So here, the core legal challenge here: how do we ensure these regimes, and surely at least some regime, but it is not include, but not limited to the previous regimes here. So how could we ensure these regimes interact with synergy and avoid conflict? So the BBNJ, we know that will be entering into force very quickly in the next January 2026, in accordance with Article 68. Point 1, which reads as follows: this agreement shall enter into force 100 days after the days of the deposit of a 60th instrument of ratification, approval, acceptance, and accession. So until now, we already have Sorry, I skipped here. So until now, we have 145 signatory parties, signatory countries, and 75 parties. And the most recent news that is China already ratified BBNJ, signatured in the first stage in 2023, first stage, and recently just ratified BBNJ by the National Standing Committee, the most highest level of China's legislative body. And still at the final stage until for the signature by President Xi. So this is the most recent news. China ratified BBNJ and following, waiting for the final signature by the president. So here, for the BBNJ and relating to the blue carbon activities, here are two critical governance tools provided by BBNJ. For example, the Part 3 and Part 4. The Part 3 ABMT provides the first ever global mechanism to establish a comprehensive cross-sector network of marine protected areas in the high seas, and Part 4 ERA established a clear process and thresholds for conducting ERA for planned activities in ABNJ that may have more than a minor or transitory effect. So there is the direct relevance for ocean climate action if we check this the BBNJ agreement. For example, the protection part, ABMT can use to protect ecologically significant blue carbon sinks in ABNJ, like amongst the deep sea ecosystems and regulation. So the ERA provisions will be the primary legal tools to assess, regulate, and manage large-scale ocean CDR activities in the high seas. Here, so I'm talking about the legality, so after the legitimacy part. So pathways in international law for achieving ocean and climate synergies take governance. So I know that in this two days conference, so we mentioned many times about the climate change, the adversary planning, but I think BBNJ could also be regarded as a international law source that connect the climate change and ocean governance. So I think it's quite a premier research here. So the BBNJ may request the ERA for blue carbon activities. The agreement also requires ERA for activities that may affect the marine environment on the high seas and sets more precise and substantive threshold and factors for the conduct of ERA than are currently provided for under the convention and existing customary international law. So different types of blue carbon activities may be subject to the cumulative impacts in areas within and beyond national jurisdiction, the strategic environmental assessment and information exchange and monitoring provisions of the current ERA components, as well as those relating to the planned activities. So in the light of existing practice with regard to blue carbon activities, so I still use the general understanding for the blue carbon activities, including the ocean CDRs. So the threshold requirements of the agreement may exempt many small-scale activities from the requirement for an EIA, as they may not potentially harmful enough to require a full EIA. However, given the dynamic nature of blue carbon activities, which is still ongoing by the experiments and the scientific activities of the marine scientists, the marine aquaculture, the natural scientists, their work. So these scientific and technology advancements help us to understand the blue carbon activities more precisely in the legal and governance way. So I call it a dynamic nature of blue carbon activities, and their high degree of uncertainty. The ERA provisions of the agreement should still be examined and benchmarked prior to the implementation of blue carbon activities. So the BBNJ could facilitate international cooperation on blue carbon conservation. So this agreement advocates that states should strengthen international cooperation in marine biodiversity conservation, especially in ABNG, which will help coordinate national actions in blue carbon conservation, promote the sharing of relevant technologies and funds in the international community, and improve the effectiveness of the global blue carbon conservation, and further strengthening the rational interaction between the ocean and climate legal regimes will help to better protect the oceans, achieve synergies between international platforms and tools related to ocean and climate change issues, and improve the ocean's ability to mitigate and adapt to climate change, thereby promoting the sustainable development of global marine ecosystem. So for China's role here, so China already established a strategic framework. We call it ecological civilization for blue future. The guiding philosophy reflecting the national policies and also law, that is ecological civilization. This is China's paramount national strategy relating to the marine environment and also the ecology, integrating environmental protection into all aspects of economic and social development. So ocean governance and climate action are not separate, so they are core components of this single unified vision. And you may heard about that, the China's dual carbon goals. So which means the national pledge to peak carbon dioxide emissions before 2030 and achieve carbon neutrality before 2060. So this is the fundamental driver of China's energy, industrial, and land use, and including the sea use policy. Next one, besides the guiding philosophy, China also is promoting a sustainable blue economy. So shifting from resource-intensive marine development to a high-quality sustainable blue economy as its ambition. And this involves coordinating marine protection with economic development, emphasizing marine science, technology, and green industry. Next one is a global vision, so maritime community with a shared future. So in China's vision for global ocean governance, advocating for cooperation, shared benefits, and collective response to shared challenges like climate change. So more concentrated here. So China's perspective relating to the blue carbon action from the domestic and international level. The blue carbon as a national priority. The blue carbon is recognized a critical high-efficiency nature-based solution. And in China's 14 five-year plan, so China is right now writing and designing the 15 15th 5-year plan. So of the last one, the 14th 5-year plan. So it actually covers a period of 2011 to 2025. Explicitly manages enhancing the carbon sink capacity of ecosystem. So I'm not working on the standards of the blue carbon, but I have colleagues that they already they are working very diligently to issue the guidelines and the standards for the blue carbon trading system, the markets, blue carbon trading markets in China. And this includes binding targets for large-scale ecological protection and restoration with a specific focus on coastal ecosystem. For the implementation, so this is what I talk about, the market mechanism. So China already issued some large-scale restoration project implementing the world's most extensive coastal restoration projects, particularly for mangroves in Guangdong, Guangxi, and Hainan province. And China established the domestic carbon trading markets in 2017 as some experiments. So since 2017, and this experimental period lasted for I think more than 6 or 7 years until recently, recent 2 or 3 years. So this national carbon trading market is not just stayed at the stage of experiment. It is a final formal official carbon trading market. And what I talk about the standards, the guidelines for the blue carbon trading market is under the level of a whole national carbon trading market. So the goal is to integrate blue carbon credits into the China certified emission reduction scheme, creating a powerful finance incentive for conservation and restoration. And China want to incorporate the blue carbon into its NDCs and supports the inclusion of blue carbon and other ocean-based solutions in Paris NDC. So this is a key pathway to link national climate pledges under the UNFCCC with tangible ocean action under the UNCLOS. And as noted, so I mentioned this point. So for the other parties' promise. So and the next one is unlocking international carbon market. So I mentioned before. For the China's part, so China's view the Baku conference, the Article 60 to the bilateral and 60.4. I mentioned that. So provided the China views this as a key opportunity for global cooperation. So first, domestic carbon markets, and China look forward to sign some bilateral and multilateral agreements according to the previous the clause I mentioned, and explore this domestic blue carbon initiative to the stages of international cooperation. So and another dimension here, that is South-South cooperation and blue partnerships. China is actively sharing its expertise in blue carbon science and monitoring and restoration technology. So this is a key components of the blue partnership and the Belt and Road Initiative, providing capacity building and technology support for other developing countries. Here, so China is an active and constructive participant in the BBNJ negotiation. So China played an active role in the negotiation part, the IGCs, and was one of the first major countries to sign the agreement two years ago. And we know that recently ratified. So the position on the BBNJ implementation, so at least from my individual researcher observation. So support for tools. The strong support for the ABMT and ERA mechanism as essential for conservation and sustainable use, and science-based insists that the decisions, for example, identifying MPAs, assessing ERA, must be based on the best available science and avoid politicization. and balance. The agreement must balance conservation with the legitimate rights of states to sustainable use, for example, fishing, navigation, and marine scientific research in the high seas, and not undermine the BBNJ agreement as an implementing agreements of UNCLOS must not undermine existing legal frameworks like the IMO, regional fishery management organizations, or the UNFCCC, and also because I studied and researched for the polar law for many years, and not undermine the Antarctic Treaty system. So the capacity building, a primary focus for China is ensuring that path for capacity building and transfer of marine technology is robustly implemented to assist developing states. Okay, China's vision, conclusion here. China's vision for ocean climate governance. First is domestic action. So China is trying to demonstrating its commitment through tangible domestic action, implementing its ecological civilization vision, investing heavily in blue carbon restoration, and building innovative market mechanism, like I just mentioned. And second, the legal coherence, advocating, at least trying to advocating for synergy. So the climate regime and the ocean regime must work in a coordinated but distinct manner. So you could check the China's position submitted to the ICG and UNCLOS. So China firmly opposed the legal conflation proposed by the UNCLOS pollution finding. So three, science first regulation, a pragmatic approach. So blue carbon activities, especially the CDR, should be legally characterized as marine scientific research under UNCLOS, and their potential impacts must be rigorously managed and assessed under the ERA framework of the BBNJ agreement and the London Protocol. And fourth one is multilateral cooperation shared future. China is a constructive participant in the BBNJ process and promotes blue partnership, for example, by the Belt and Road initiative to build a global governance system that is pragmatic, balanced, inclusive, and effective for both the ocean and climate. Okay, this is my end of the presentation, and thank you, and more turn. Crazy.
Thank you very much. We can now have the fourth presentation. It is by Mr. Zhonghua Chen. He is a PhD candidate at the Faculty of Law of the University of Ghent, Belgium. And he will speak about a legal technical subject applying UNCLOS. No, that's the subject of his research project, apply UNCLOS to address climate change, and the intervention will be on due diligence obligations under UNCLOS. So whether due diligence obligation, which is normally believed as an obligation of conduct, could be considered also an obligation of result. Please, Mr. Chen.
Thank you, and good afternoon, everyone. I'm Zhonghua Chen from Ghent University. First of all, okay. And first of all, I would like to thank the organizers for your kind invitation, which gave me this valuable opportunity to share this topic, which is highly focused on the paper which I recently published on the Maritime Safety and Security Law Journal this year. However, I want to notice that when I was drafting this paper, the climate change advisory opinion before the ICJ was still pending, and now it was released. So today, my presentation is not simply a repeat of my paper. I will add some fresh informations concluded by the ICJ. And for today's presentation, we'll proceed in three parts. First, I will briefly introduce some key concepts. And second, I will identify the core points of controversy. And finally, I will discuss what analytical value this dichotomy brings to our understanding of the due diligence obligations in the context of climate change. So I think the first and most important issue we should address is due diligence. It is a very important concept, and in the three existing advisor opinions delivered by the ITLOS, all of them had mentioned due diligence. However, just as the ITLOS concluded in 2011, they think that the concept of due diligence, it is very hard to be described in precise terms. And among the factors that make such a description difficult is it is a variable concept. And nowadays, the topic due diligence in international law has been incorporated into the long-term work before the International Commission. The Commission tried to give a precise definition of that. In the view of the Commission, due diligence has been understood as a duty or standard of care applicable to a state's conduct, which means that the concept of due diligence is closely connected with the conduct of the states rather than the result. And in the course's advisory opinion, ITLOS, with no surprise, has defined Article 192 and Article 194, Paragraph 1, Paragraph 2 as the due diligence provisions. The next one is the conduct and result dichotomy. Today, because of the time constraints, I will not give a very deep analysis of the definition of them and how they develop from the law of state responsibility. And the most important thing I want to stress today is that in the ICJ climate change advisor opinion, the court has give a firmly conclusion, which means that the court observed that some obligations may exhibit characteristics of both obligations of conduct and obligations of result. That means in some circumstances, they may coexist in one obligation. And following, the court also stated that nor it may be maintained that one type of obligation is more onerous than others. That means that the obligations of conduct is not naturally more stringent than that of conduct, than that of result, and vice versa. So, the conclusion reached by the ICJ had addressed one of the major opinions raised by the small island states in the advisory proceeding before the ITLOS. Now we will come to the core points of controversy. This brings us to the central controversy. Some states argue that Article 192 and 194 should not only be understood as obligations of conduct, but they should also go beyond due diligence, and they should incorporate obligations of result. Their reasoning mainly relies on three arguments. The first argument is that obligations of result are more stringent than obligations of conduct. And as we have discussed, the ICJ has firmly rejected this assumption. The second argument is quite interesting. During the advisory proceedings, some states represented by the causes, they quoted some case law in order to establishing that the term necessary to ensure in Article 194 can also be interpreted as incorporating obligations of result. They have quoted so many cases, and today I want to mention one of them is the OSPA Convention, the OSPA arbitration between the Ireland and the United Kingdom. In this case, one of the contention is that Article 9, Paragraph 1 of the OSPA Convention the tribunal concluded that in this paragraph, the term "to ensure" it represents one of the obligations of result, which means that the United Kingdom is obliged to make the information available to the public. And the COSIS in this case, it relies on this conclusion. They want to equal it with the Article 194 in the UNCLOS in the context of climate change. However, I think the intended results between Article 9, Paragraph 1 of the OSPA Convention and the UNCLOS is totally different. Because the intended results of Article 9 of the OSPA Convention is a disclosure of information, a specific and concrete outcome. And by contrast, the intended results of Article 192 and 194 is to prevent, reduce, and control the marine pollution, a broad and complex and collective objective. So we should not confuse an intended results with the obligation of results. The distinction between the intended results and obligations of results also reflects in the third point of the raised by the COSIS. They believe that the temperature goal set in the Paris Agreement is an obligation of result. In fact, that is an intended result that state parties collectively strive to achieve through the coordinated action, and the practice of the ICJ in the previous case has affirmed that the compliance is assessed based on the reasonableness of a state's conduct rather than the ultimate result. In response, ITLS also emphasized the importance of identifying the intended results embedded in these due diligence provisions. Okay, and beyond them, the key point I want to share today is, what does the conduct and the result dichotomy allow us to understand about due diligence? Here, I would like to draw your attention to ITLS reasoning. The tribunal states that in the context of climate change, the due diligence obligation is stringent. So, one question raises, how should we understand the term stringence? And according to the tribunal, this means that the obligation is not a pure obligation of conduct. In other words, states are expected to actually achieve certain results in the implementation of their measures. However, what we should do is to achieve a coherent interpretation between the conclusion that the due diligence is one of the obligations of conduct, and it is not a pure obligation of conduct. In this regard, stringency and objectivity are closely connected. This slide, it shows the structure of part 12 of the UNCLOS. After the general obligations in the first section, the convention has set out a series of specific obligations beginning in section 2. To achieve the stringent due diligence, states, they must perform these specific obligations fully and in good faith. And importantly, these obligations are objective, which means that they are not left to 100% the discretion of the states. Moreover, some of these obligations do require states to achieve concrete results. For example, the obligation to adopt domestic legislation, or the obligation to conduct environmental impact assessments. And this slide, it shows the elements for the compliance of the due diligence, which is identified by the ICJ in the recent advisory opinion. In my analysis, I classify these obligations into the direct elements and indirect elements. It was inspired by the ITLS advisory opinion in 2011. The direct elements refer to the obligations that are expressly provided in the convention, And the indirect elements refer to the considerations that must guide the implementation of these direct obligations. For example, the precautionary approach. With this, we can reach a coherent interpretative conclusion. Articles 192 and Article 194 remain obligations of conduct. However, because these obligations are stringent, the fulfillment of due diligence requires states to perform certain objective and specific obligations set out under Part 12 of the UNCLOS. And some of these specific obligations do require state parties to achieve the concrete results. Okay, that is what I want to share today. Thanks for your listening, and I'm looking forward to your questions.
Thank you very much. And the last speaker of this session is Dr. Ardito, Giovanni Ardito. After having earned a PhD in the University La Sapienza in Rome, he was a public officer with the Secretary General of the International Seabed Authorities. And in such capacity, he attended the negotiations for the BBNJ agreement. The subject of his intervention is facing biodiversity loss in marine areas beyond national jurisdiction, the entry into force of the BBNJ agreement, which is expected for the middle of January of the next year. Please, Mr. Ardito.
Thank you very much. Thank you very much, Mr. Chair. You thought it was the end of it because I was not seated there. I'm sorry. I'm gonna steal a few more minutes from your time today. So at the outset, let me thank, of course, Gemma Andrione for having organized this event. I think it's very important that we created this platform for discussion on two very relevant topics of biodiversity loss and climate change. And it is, of course, a pleasure to take part in this discussion on how international law, what happened? Okay. International law of the sea can respond to the accelerating of in the loss of marine biodiversity and climate change, including, as it is the case for my presentation, in areas beyond national jurisdiction, the ABNJ. So my presentation today will look at the agreement, as it was introduced already, on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, the BBNJ agreement, as a tool to coordinate the plethora of legal and policy frameworks on the conservation of marine biological diversity. And what I would like to bring today is a rather perhaps practical approach to it. As it has been mentioned, I was one of the officers in charge of the BBNJ agreement at International Seabed Authority, or ISA, as I'm going to refer to. And we spent quite a lot of time looking at how the BBNJ agreement would have interacted with the mandate of global organizations, including ISA, and the complementary or even conflicting conservation measures that the BBNJ agreement is now called to reconcile. And it is therefore exactly this relationship between the BBNJ agreement and existing global, regional, and sectoral frameworks that I would like to look into today. So Professor Le Floch has already extensively discussed ISA mandates, so I don't really think I need to go there. And I will also not focus on any introductory remarks on the BBNJ agreement given the audience today. So I'm going to go straight to the fact that today only about 10% of the global ocean remains in a pristine state. And yesterday we heard extensively about the finding of the IPCC and the value that international courts have attached to its report. So, well, according to such reports, thousands of species have already disappeared before scientists could even properly describe them in the deep sea. So this is particularly true for the seabed and the ocean floor beyond national jurisdiction, the area with capital A. So climate change is also amplifying this crisis because since 1970s, the ocean has absorbed already more than 90% of the excess heat in climate system. It is in this context that the international community negotiated for almost over 2 decades the BBNJ agreement, which, as we all know, was finally adopted in 2023 after a non-stop 32-hour negotiating section, and that following the latest ratification will enter into force on 17th January 2026. So, let me now just briefly set the stage. So we all know that within national jurisdiction, coastal states can adopt and enforce their own conservation measures. Beyond national jurisdiction, however, there is no single authority. Protection of the ice seas and the area depends heavily on cooperation among states, particularly through international organizations. And over the years, a patchwork of sectoral, regional regimes has emerged. So we have those governing fisheries, shipping, seabed mining, and pollution from different sources. Yet this framework remains highly fragmented and uneven, as it has already been observed in other presentations, both geographically and functionally, because we have some activities which are heavily regulated, while others are not addressed at all. We also have large oceanic zones that still fall outside of any dedicated protection regime. In short, despite decades of legal and institutional growth, the ocean health indicators continue to deteriorate. Now, recognizing these shortcomings, states adopted in 2023 the BBNJ agreement. It is the third implementing agreement under the United Nations Convention on the Law of the Sea, alongside the 1994 Agreement on Part 11 of the United Nations Convention on the Law of the Sea and the Fish Stock Agreement. In some respect, the BBNJ agreement is closer in form to the Fish Stock Agreement, as it is a self-standing treaty to which any state or regional economic organization may become a party, regardless of whether they are parties to the United Nations Convention on the Law of the Sea. As such, the BBNJ agreement does not formally modify or amend the convention. Rather, it strictly applies inter partes, meaning that the rights and obligations of states parties to UNCLOS that do not become a party to the BBNJ agreement do not change. So I think this is a key point to bear in mind, and it is also oftentimes overlooked. Nevertheless, the close relationship between the BBNJ agreement and UNCLOS is reflected in the general objective of the agreement, and I quote, to ensure the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction for the present and in the long term, through effective implementation of the relevant provision of the Convention and further international cooperation and coordination. As far as our conversation today is concerned, 2 tools of the BBNJ agreement are the most relevant to halt and possibly reverse biological loss. Environmental impact assessment and area-based management tools, including marine protected areas. So given the time limits, I will just focus on area-based management tools. Now, part 3 of the BBNJ agreement creates the framework for developing a comprehensive, representative, and well-connected system of area-based management tools, including marine protected areas, with 3 main objectives in mind. The first one is strengthening the resilience of marine ecosystem to human-induced stressors, such as climate change, acidification, and pollution. Second, managing cumulative impact across sectors. And third, supporting socioeconomic goals, including food security and cultural values. Area-based management tools are defined broadly to include any instrument by which one or more activities are managed in a defined area to achieve conservation and sustainable use objectives. And an MPA, a marine protected area, is one of the possible area-based management tools. That is to say, a site which is managed to achieve long-term biodiversity goals through coordinated regulation of all relevant activities. The process for establishing an area-based management tool under the BBNJ agreement is collective and transparent. So we first have states submitting proposals, then a scientific and technical body reviews them. After that, we have broad consultation, allowing other institutions to comment upon. And finally, the Conference of the Parties, or the COP, decides, ideally by consensus, or if this is not possible, by a 3/4 majority. And the BBNJ agreement also provides for opt-out measures as a diplomatic tool to overcome any deadlock on the establishment of marine protected areas. Now, in principle, the mechanism set by the BBNJ agreement represents a valuable tool to ensure conservation and is indeed promising. However, one of the main issues for determination by the Conference of the Parties, of the BBNJ of course, is how this mechanism will interact with the existing ecosystem of institutions that have developed or can develop their own area-based management tools and marine protected areas within the remit of their respective mandates. And also it is yet to be determined how to reconcile the conduct of certain activities authorized by other organizations like ISA in areas that are likely to be identified as marine protected areas under the BBNJ agreement. As the president of the BBNJ conference stated a few days ago in another international conference, the BBNJ agreement provides directions, but not details. But at the same time, we know that the devil is in the details, right? So this is not just a scenario planning, rather a practical case that we are already confronted with even before the BBNJ agreement enters into force. Let me now focus on a very concrete example which is taken from my experience in the relationship between the BBNJ agreement and ISA. Under Part 11 of the Convention, ISA organizes and controls mineral-related activities in the area, as we heard already, for the benefit of humankind, and must ensure effective protection of the marine environment from the harmful effect of seabed mining, Article 145 of the Convention. To implement this mandate, ISA has developed, among the others, regional environmental management plans. And these plans provide a regional framework for managing exploration and future exploitation of mineral resources and identify areas of particular environmental interest, which are de facto marine protected areas where no exploitation can be carried out to protect fragile ecosystems. Now, this is the first regional environmental management plan which was adopted. As you can see, the areas in yellow and blue, I think, are exploration licenses, and those areas that you see in green and red are areas of environmental protection, so marine protected areas where no mining activity can be carried out. Here we are in an area in the Pacific Ocean which is around 600,000 square kilometers, so it's quite a huge area of the marine environment. Let me here open a parenthesis we already heard of. One of such ISA protected areas overlap with an existing site which has been allocated by the United States of America, which is not party to the convention as we know, and is the only country still having a unilateral legislation to award its national exploration and exploitation rights in the area. You might be aware of the most recent development in this domain, and we already heard about it, which triggered very interesting questions of law of the sea in general international law, but very interesting question also for the application of the BBNJ agreement. We are not going there today, I'm sorry to say. So the Regional Environmental Management Plan for the Clarion-Clipperton Zone incorporates key principles in the BBNJ agreement, the common heritage of mankind, the precautionary approach, ecosystem-based management, and it is around the ramp, this one, that exploration licenses are now being granted by ISA. So the entry into force of the BBNJ agreement poses some question, and here we are. What if the BBNJ COP designates a marine protected area that overlaps with an ISA mining contract, say, in the Clarion-Clipperton Zone? UNCLOS grants security of tenure to all its contractors, meaning that the authority cannot unilaterally revoke or suspend contracts as a result of an eventual decision of the BBNJ COP to establish an MPA in a licensed area. But the picture is even more complex. In fact, what if the BBNJ COP does not fully reflect the membership of ISA, and therefore its decision might not be considered binding by ISA members which are not parties to the BBNJ agreement? Moreover, while the BBNJ procedures allow for relevant international institutions like ISA to comment upon the proposal for the establishment of marine protected area to ensure coordination, they do not specify how such coordination will actually occur, or how potential conflicts like those I'm mentioning can be resolved. So unless clear mechanisms for cooperation are established, it's self-evident that this parallel system risks colliding rather than completing one another. As we approach the BBNJ agreement entering into force, the preparatory commission, the PrepCom, has been working intensively to make the institutional framework operational, so the Conference of the Party, the Scientific Committee, etc. Its most recent session was held in August 2025 and was very significant. A central question for this meeting was how the BBNJ new organs will coordinate with existing sectoral and regional bodies, including ISA, IMO, and regional fisheries organizations. And two key documents were put to the attention of member states: the draft rules of procedure of the Conference of the Party and the draft arrangement to enhance cooperation with relevant global, regional, sub-regional, and sectoral bodies. Now, unfortunately, both drafts still lack clarity on how institutional cooperation will operate in practice. So the draft rules of procedure contain provisions on observer status, which might be one of the avenues for this coordination. Interestingly, they do not make any distinction between non-governmental organizations and intergovernmental bodies with treaty-based mandate under the UNCLOS, like ISA. So this means that procedurally, ISA, IMO, and other international organizations are on the same level as NGOs when providing comments for the establishment of marine protected areas. One could wonder whether this approach could be reconciled with the BBNJ agreement's own requirement for coherence with existing framework and consistency with UNCLOS as mandated under Article 5 of the BBNJ agreement. Similar, the second document, which is the draft arrangement for cooperation, merely refers to generic consultation and information sharing. So this document does not specify how to ensure consistency when the membership of the BBNJ agreement might differ from those of other organizations. This is not just an hypothetical issue. Look at Russia, for instance. Russia already announced back in 2023 that it would not participate in the BBNJ agreement, yet it remains one of the most active ISA members. So if, say, the Conference of the Party were to designate a marine protected area affecting an area where a Russian contractor operates under the ISA regime, which I can tell you is not unlikely at all, then the institutional and political implication would be pretty complex to manage. So Poland is in a very similar situation, and this should be a little bit more interesting for us, given that Poland is part of the European Union, and the European Union is taking responsibility for the negotiation of marine protected areas within the BBNJ context. Because Poland has an exploration license in the Atlantic Ocean, which overlaps with an active sulfur vent, which is likely to be designated as marine protected area by the BBNJ COP because it has been identified as an ecologically or biologically significant area under the Convention on Biological Diversity. So to be clear, this should not lead to conclude that the BBNJ agreement is set to fail, not at all. On the contrary, this discussion reveals that the architecture of coordination is still very much under construction, and the better approach is chosen now, since the very beginning, to secure full cooperation, the better results will be achieved. The next months will therefore be decisive in translating the general commitment to cooperation and coordination into concrete procedural mechanisms. And to me, this means, first of all, granting special observer status to UNCLOS-based organizations. And this is nothing new, because if you look at the meeting of the state parties to the United Nations Convention of the Law of the Sea, it recognizes a specific status to organizations like ISA, given their specific role. Second, setting up structured consultation channels among secretariats. I know it's a difficult question because we don't even know where the secretariat of the BBNJ will be located, but still, the sooner the better. And then operationalizing the principle of not undermining and ensuring consistency with UNCLOS, which lies at the heart of Article 5 of the BBNJ agreement. So at the moment, with the last PrepCom session fast approaching, these details remain vague and, most importantly, very contentious. So in such scenario, no one can exclude the risk of overlap or institutional tension that might well persist even after the entry into force of the BBNJ agreement. And this, to me, would clearly defeat the scope of the BBNJ agreement. So to conclude, the adoption of the BBNJ agreement marks an historic milestone in the progressive development of the law of the sea because it provides the first comprehensive framework for conserving marine biodiversity in areas beyond national jurisdiction. However, its effectiveness will depend on two conditions. The first one, the achievement of a critical mass of ratification. And you already know what it means because look at the fish stock agreement. And the second is the quality of coordination with existing institutions, including ISA, as per our case study. So the principles of consistency with UNCLOS and not undermining must guide every single decision of the COP. If the new regime succeeds in working hand in hand with existing ones, we may finally see a coherent and truly science-based system of global ocean governance. If not, well, the result could simply be another layer of fragmentation, which we fought against over the past 2 decades. So as we stand on the blink of its entry into force, the collective challenge is to ensure that the BBNJ agreement becomes a living, but also practical instrument, which is capable of reconciling conservation, sustainable use, and institutional coherence in the vast global common that is the ocean. Thank you for your attention.
Thank you very much. So, looking at my watch, we have completed the 5 interventions, and I thank all the speakers for having complied with the time limit. Now, we have 22 minutes, no, 12 minutes. We are expected to close at 4:30. I'm looking at Professor Andreone, who is the leader of our work. How flexibility do we have? We have much flexibility. So until 5 o'clock. So I open the time for questions and answers. The speakers have told me that they are ready to answer not only easy questions, but also difficult questions. So I invite the audience to address difficult questions to the speakers. Yes.
I'm sorry to disappoint because my questions are very easy.
Yeah.
So I have one question for the first speaker and one for the last. So to Roberto Virzo, question. So you refer to the Law of the Sea Convention as the Constitution of the Oceans. So doesn't that give it a certain preferential ranking in the hierarchy of treaties? So you talk mostly about treaties that are compatible with the Law of the Sea Convention, but what if they are not? What if there's a clash that cannot be interpreted away? So does the UN Convention of the Law of the Sea then have a status similar to the UN Charter, for example, that it prevails over bilateral agreements that may be inconsistent with it? Very easy question. Okay, now for Giovanni. Yeah, so a bit halfway through your presentation, you said that the BBNJ agreement, once it enters into force, does not really change obligations of states not party to the BBNJ agreement, but party to the Law of the Sea Convention under the latter convention. But maybe I misunderstood, because I don't really agree with that. So it is an implementing agreement. So you could also see it as a subsequent practice or a subsequent agreement in the sense of the Vienna Convention Law of the Sea. So that would also have an impact on how the obligations under the UN Convention on Law of the Sea have to be understood, even for parties, even for states not party to the BBNJ agreement. So maybe you can be a bit more specific about this.
Thank you, Otto, for your easy question, which is not easy at all. Yes, of course, from a formal point of view, there is no doubt that you are right. There is any Article 103 of the United Nations Charter in the United Nations Convention for the Law of the Sea. Article 103 establishes a clear superiority or prevalence in comparison to other treaties. We have no such article in the United Nations Convention for the Law of the Sea. However, first, any subsequent agreement concerning the Law of the Sea usually refers to the United Nations Convention for the Law of the Sea. So there is a kind of de facto coordination with the Convention. In the case of the BBNJ or the Fish Stock Agreement, which are implementing agreements, of course, there is a without prejudice clause concerning the United Nations Convention for the Law of the Sea. So, in my opinion, I think that it's up to states or and international courts and tribunals to give an interpretation of the Convention and the other treaty, the external treaty, in a way to not to have this fragmented solution, but just to have coherence between the treaties to be applied, including the United Nations Convention for the Law of the Sea. At one point, I say this, that the Convention is a kind of constitution of the oceans, but in the framework of what I said, the legal order for the seas and the oceans, which has been established by the United Nations Convention for the Law of the Sea. So the Convention needs to be implemented, integrated by the other treaties. So our idea should be to have a system composed by the Convention and the other treaties. So to have a kind of system with the Convention by itself cannot take into consideration all the issues related to the Law of the Sea. The Convention is open to a lot of external instruments, the variety of clauses of reference I quoted during my presentation. For example, Lorenzo this morning focused on the IMO. There are several articles in the Convention which says that states must comply with the regulations adopted by the IMO. So my idea is that we have a system established by the Convention. Here we have the formal register of the International Tribunal for the Law of the Sea. In 2015, in the other advisory opinion, The tribunals concerning the legal order for the sea and the oceans, if I'm not wrong, the tribunal said that also the law and regulations adopted by states concerning the exclusive economic zone form part of the legal order for the seas and the ocean. So the idea is to have a comprehensive system composed by the convention and the other treaties. And one more point, the United Nations, the systemic integration, the United Nations Convention for the Law of the Sea is part of the international legal order. So in the meanwhile, we have from one side this system, which is a passive system composed by the convention and all the other treaties, but they are not something different from the international legal. The UNCLOS belongs to the international legal order. It's not something different. It's not a kind of a system, a self-restraint system, not at all. My idea is that we have a system composed by convention and other treaties, which are part of the international legal order. So it's up to the interpreter, to the judge, to the states to find coherence between the system. This is our goal as lawyers when we have to handle these instruments, which are very important to be applied in the case of the law of the sea.
I can use this one if it still works. Yes. Okay, so thanks for the question. You touched upon a very interesting element here. So I think here we probably should reflect a little bit more on how we classify the BBNJ agreement and what we mean by implementing agreement, because the history of the United Nations Convention on the Law of the Sea teaches us that implementing agreement means everything or nothing, depending on the circumstances. I mean, the 1994 agreement amends the convention. It's called implementing agreement, but it's an amendment of the convention, right? The fish stock agreement, in my opinion, really implements some provisions. Now, look at the BBNJ agreement here. The matter is a little bit more complex, because if you look at the regime of environmental impact assessment, then I would definitely say that the BBNJ agreement is an implementing agreement, because it's going to implement some provision on environmental impact assessment, which are contained in the convention in a very, let's say, general way. But if you look at the marine genetic resources, for instance, it's a topic which is not dealt with in the convention at all. So, I mean, you are not implementing anything specific, but rather adding up to what was neglected at the time. In 1982, no one knew about marine genetic resources, no? So what I'm specifically referring to my presentation on marine protected areas, what I wanted to refer to here is the fact that look at the governance architecture of the BBNJ agreement, right? Most of that architecture is made up for marine protected areas. Now, if you have a decision taken by the conference of the party, and you already have some countries saying at the moment of the conclusion of the intergovernmental conference, declaring that they don't consider themselves bound by any subsequent practice arising from the implementation of the BBNJ agreement, and we already have some countries saying so, then it's clear that this is not going to be applicable to them. Plus, here you have a conflict between two different decision-making mechanisms. Because, and again, getting back to my example before, there is a decision-making mechanism for the establishment of marine protected areas in the ISA, and also potentially applicable also in the Conference of the Party. Now, if I am a country not party to the BBNJ agreement, but party to UNCLOS, and therefore de facto a member of the International Seabed Authority, I would not recognize the measures under the BBNJ agreement, but those established under ISA. So here it's a matter of how to coordinate, whether the Assembly or the Council of ISA will just say, okay, we are gonna take that area-based management tool of marine protected area as a measure also applicable within the broader framework of ISA, for instance, and if that's the case, then you need a council or assembly decision with other majority, which is an additional layer of complexity compared to, a decision taken by the Conference of the Party of the BBNJ. So I hope I answered your question. And if I may, I know it's a bit irritual, but may I ask a question myself?
Yes, of course.
Thank you very much. Thank you. No, actually, it's rather, I mean, unless there are other questions before me, because I don't want to steal the floor to anyone.
Are there any other questions?
All right. So I'm going to be brief. I mean, maybe it's a comment, not really a question, but I was very interested by the presentation of Professor Le Floch, maybe just because it's, you know, something I'm more familiar with. But I actually have, and I would like to hear your views on that. So the first one is, you rightly mentioned about the fact that we don't know much, right, about the ocean before, and based on this, we can't really start. We couldn't really start, or some states say that we can't really start deep sea mining. So my question here, and based a little bit of what I could witness, is how much science do you need it is necessary to start deep sea mining? I know it's a hard question, but the reason why I'm asking it is because sometimes what is overlooked is the fact that ISA has not a mandate to conduct marine scientific research. Well, of course, it has a mandate to conduct marine scientific research, but the way you collect the data that you need for exploration is through exploration contracts. And when you allocate an exploration license, you don't do an exploration license for the whole area. You do it for a very small piece of the area. So if you look at the advancement of some exploration areas, well, it's pretty advanced, the knowledge that we have, but we only have knowledge of that specific license area. Is this enough to go ahead with deep sea mining? Because if we are going to wait to know, you know, the systems of the whole ocean, we will never be ready with deep sea mining. And not that I want to go ahead with deep sea mining, but rather just to understand what is the threshold, because otherwise Part 11 of the convention is pretty useless, right, at this time. And the second question, the second comment is, I rather disagree with respect to the fact that in the absence of a mining code, there is no chance for having an exploitation license. Meaning, I think here, and this is something that is taking hostage member states in drafting the mining code, I think here we have a very important point, which again is overlooked. Adopting a mining code does not mean allowing deep sea mining to start. And I think the campaign which is being carried out now is, oh, if you adopt the mining code, then deep sea mining will start. It's not true at all. You are just putting in place the rules. And we have other examples. We have the Wellington Convention, and then on the Antarctic resources. And then, of course, we have the Madrid Protocol, and no exploitation is taking place. But not because you have rules, it means you're going to start. But you're going to put those thresholds, which may become a reference point for other countries. Particularly within national jurisdiction, because as you correctly pointed out, in the Pacific Ocean or in Norway, they are ready, but there is no rule, no international rule binding them. While if you have a mining code established at international level, that is, and this goes back to what Professor Virzo was saying, it's the rules, the rules which represent a threshold that we need also within national jurisdiction. And last point is, I don't really understand, but that's me, the reference to TMC. Meaning, TMC is not a member state. So here the point is, who is behind TMC, which is Nauru? We can question whether or not Nauru has the proper legal framework to exercise control on TMC. But I feel like we are focusing ourselves too much on a private company, TMC, whether we like it or not. But the reality is that company can operate because a member state, which is Nauru, is exercising its right under the convention to sponsor a private company based on what the International Tribunal of the Law of the Sea stated in 2011. So they first asked the tribunal, can I sponsor a private entity even if I am a developing state and with all my limitations? And they said yes, and they did so. So personally, I myself don't like TMC, right? But what I feel is strange is that we are talking about a private company at ISA, forgetting that it's a right of a developing member state provided for under the convention to propose to sponsor an activity and to have it being carried out by an entity you sponsor. So, I mean, I know it's a controversial topic, and but just you know, to put a different perspective.
I agree. Okay. First question, I would just quote Douglas Guilfoyle. The beginning of commercial scale seabed mining has been 10 years away for 16 years. So I don't know what's going to happen. I'm not a scientist, not at all. But I just want to follow what scientists say. So I don't know, I really don't know what's going. I understand that if you want to have some benefits, you have to have exploration on a large square, no? That's it. So you need to have the knowledge about this area. So I don't know, but, and you know, I said France 3 years ago was for the exploitation, and President Macron changed his mind in the plane from Paris to Chamenchek. So I don't know, but what I can say, in fact, I was really impressed by the scientific proclamation. That's why I think I'm from a precaution purpose. Your second question was about? A comment?
No, well, it was rather a comment. It's, you know, the fact that sometimes we feel like adopting a mining code means approving exploitation.
I totally agree with you. But the problem is what content in the mining code. And there is a strong division between France, Germany, Romania, and China, Russia, South Korea. That's the problem. And I don't know, I really don't know what is going to happen. I think, like what I say, I think we need a decision, an international decision, and a mining code with environmental preoccupation, you know. That's what I think, but the problem, there is too much strong division between two camps, and I don't know, and I think this is good for United States of America.
Exactly.
So that's what I say. The problem is today is unilateralism or multilateralism. I am for multilateralism and the International Seabed Authority. That's why, so I'm sorry if I made a mistake, but I'm pretty sure that we need a mining code. Oh, sorry, we need a mining code. But the problem is what in the mining code? And there is so strong division. And the last question, TMC, but TMC, it's Nauru. And Nauru is a state, and behind Nauru you have TMC, that's why. And there is a strong campaign of TMC. If I remember last March, at the eve of the last days of the council session or something like this, there was this information on TMC that said we will ask America to have a permit to explore. And that's the problem. And TMC, it's Canadian, and Canada is for a moratorium. So, but I think it's not a state, of course. But if you look at Nori, which is not Nauru, but is in Nauru, beyond Nori, it's beyond Nauru, it's Nori, and beyond Nori, it's TMC. That's why.
I cannot resist, if I may, Monsieur le Président, to a question to Guillaume Le Floch regarding one element in the...
No, the microphone.
What? It's on? Yeah?
Yeah, it's on.
One element in the equation, if you take that into account, in Article 137 of the convention, there is this provision according to which no state and or natural or juridical person, Nauru or TMC, shall claim, acquire, or exercise rights with respect to the minerals, except in accordance with this part. Otherwise, no such claim, acquisition, or exercise shall be recognized. This, if there is a boat full of ore, mineral resource from TMC, going to a port in France. France is party to UNCLOS. It means property rights would not be recognized if you take that into account. I don't know whether that's something interesting to keep in mind. No, I have also for the question of BBNJ. It's perhaps provocative, but keeping in mind that 90% of the pollution, acidification is land-based, that 80% of the fish are caught in the EEZ. If you, that's my understanding of Article 5 of the BBNJ, that for RFMOs and International Seabed Authority, the BBNJ agreement should not undermine those agreements. This, what is left, except genetic resource, perhaps. But what is, because in the press, everything it was read, BBNJ will save the oceans. But to be pragmatic, what is left with the BBNJ, if you keep in mind what is contributing to pollution, acidification, overexploitation of fish? That's a bit provocative.
No, well, I'm gonna just say that I fully agree with you. Meaning, the reality is the scheme as it, I mean, overall, we all knew since the very beginning that the BBNJ agreement was trying to put itself in a position when you already have several layers in global governance. And of course, this is another institution which is supposed to, well, another set of institutions which is supposed to govern a rather chaotic landscape. But the point is correct, meaning if we already have other regimes, in theory, protecting the marine environment or having their own frameworks for environmental impact assessment and then accept genetic resources, which is really what is new, then what's the role of the Conference of the Parties? So that's why I think, well, and the BBNJ more in general, so that's why I think I am really insisting on the point that if we really want the BBNJ agreement to be successful, what you need is strong intergovernmental organization even before coordination among member states. Because, for instance, one of the points that I see as very relevant, and again, I'm going to make this example because I am more familiar with it, but if you involve the Legal and Technical Commission of the International Seabed Authority in the discussion that the scientific body of the BBNJ agreement is going to do when selecting a marine protected area, then at least you can have some sort of common views, and then the LTC is going to provide its recommendation, which is almost binding to member states. So in a way, you're going to have the Conference of the Party on the one end and the Council of ISA almost on the same page. But if you keep the two processes completely misaligned, then of course, what's the point of having the BBNJ agreement? So I fully agree with you, and that's the reason why I'm insisting a lot of this point, meaning most of the activities, and except for land-based pollution, which is of course outside from this picture, but most of the other activities have already their regulator. Sometimes it's stronger, sometimes it's weaker. In some cases, in some geographical areas, you don't have at all, but potentially you could have, like other RFMOs or other regional conventions. But the point is how they are going to coordinate and whether the BBNJ will represent a plausible and credible platform for intergovernmental exchange. I hope I answered the question.
Other questions? I have a consideration more than a question for Professor Virzo. he gave as an example of interpretation according to the criterion of systemic integration, the definition of ecosystem. It is to be understood as defined in the Convention on Biological Diversity, also within the context of international law of the sea. But I have never understood the meaning of the definition of ecosystem provided in the Convention. It says, an ecosystem is a dynamic complex of plant, animal, and microorganism communities and their non-living environment interacting as a functional unity. So I understand the Atlantic Ocean is an ecosystem. Then the Mediterranean Sea inside the Atlantic Ocean is an ecosystem as well. Then the Adriatic Sea inside the Mediterranean Sea, inside the Atlantic Ocean, is an ecosystem as well. Then the Lagoon of Venice, inside the Adriatic Sea, inside the Mediterranean Sea, inside the Atlantic Ocean, is an ecosystem as well. And then I start feeling lost, because how can the Lagoon of Venice be compared in the same category as the Atlantic Ocean? So is the definition in itself right? Has it a meaning?
Yes. Of course, Professor Scovazzi is always... I always love Professor Scovazzi. Okay, with this declaration. But in addition to this declaration, I agree with Professor Scovazzi. Of course, I used the South China Sea arbitration, which was, in my opinion, a good example for systemic integration, even if we can be, we can agree that this is not a very good definition, the one in Article 2 of the Convention of Biodiversity. Maybe it's better the one in the BBNJ, where in Article 7 we have the ecosystem approach, which is more realistic, because honestly, we can have not an ecosystem, but more, as you said, ecosystems. So there is no... maybe we can understand this studying the exclusive economic zone. When in the United Nations Convention for the Law of the Sea, in Article 61, 62, concerning the exploitation of natural biological resources by coastal state. The coastal state must fix the TAC, and when it considers the TAC, it must consider not only the specimen to be catch, so the maximum, but also the species related to that one, because of the fact that you have to consider, for example, code, but also the ecosystem of the code, so what the code is. So maybe in the convention we can find a kind of ecosystem approach in the exclusive economic zone articles concerning the conservation and management of natural resources. Yeah, the point is that every time we apply and we have to, once again, when we apply the convention, we have to take into consideration a lot of instruments. So this is the point, once again. The idea is that we have to manage all the, we need to be generalist when we study the law of the sea. We cannot be specialized only in the law of the sea, because if not, we cannot apply the law of the sea. We have to know as much as possible of international law. But I'm not sure that I answered it to you.
Yeah. So, if there are no other questions, so I think it's time that I draw some short conclusions for the session. The general subject of the session is how to harmonize environmental law and law of the sea, and in particular, how to integrate two main concerns of environmental law, namely global change and loss of biodiversity, into law of the sea standards. And there are some ways to do this task. For example, legal technicalities. As Professor Virzo said, the criterion of interpretation according to systemic integration. It means not giving priority to one instrument over another, but to make every effort in order to find a way to make them compatible with each other. And that's a way. Then another legal technicality is, as put in evidence by Mr. Chen, to give a broad interpretation to the due diligence obligation. Not only an obligation of conduct, but an obligation to make more than best efforts. That's another way to resort to legal technicality. Then another possibility is to establish a national ambitious policy for integration of climate change concerns into law of the sea, such as the policy of blue carbon conservation in China. That was the subject of the intervention of Professor Chen. That's a very interesting example of national policy that can achieve this objective. Then the BBNJ agreement can be understood as a way to integrate environmental concerns into international law of the sea. That was the subject of Mr. Ardito interventions. And even if there are some difficulties in the starting phase of the BBNJ agreement, it could achieve a contribution to this objective. But still on the table we have the main problem, which so far is more a political problem than a legal problem. And that is the fate of the principle of common heritage of mankind, which is the main achievement of the UNCLOS with its part 11. It is, in my view, the second most revolutionary principle in international law itself. The first most revolutionary is the interdiction of use of force, which is the main principle of the United Nations Charter. You, the strong states, you must refrain from using force. unbelievable. And then we have the principle of common heritage of mankind. You, the rich state, which have the financial means and the technological means to reach the deep sea bed, you must share the benefits of deep sea bed mining with the poor countries. Equally unbelievable, but we have the principle of common heritage of mankind. And now the principle of common heritage of mankind is put in question by a double attack, an attack from two different fronts. On the one side, we have the attack coming from the environmental front. That's a clash between two principles. On the one hand, we have the principle of common heritage of mankind. On the other hand, we have the precautionary principle, which is typical of environmental law. And we have the moratorium, which is proposed by a respectable number of states. Instead of achieving the sharing of benefits with the poor states, we should refrain from deep sea bed mining in order to comply with the precautionary principle. But what will be the fate of the principle of common heritage of mankind in this case? That is a major political problem, which was put in evidence by the intervention of Professor Le Floch, and for the time being, there is no solution to this question. And then we have the attack from the unilateral side, the United States legislation, the unilateral exploitation of the deep sea bed. So now the principle of common heritage of mankind is put in question. And that's the main challenge we have to face now. And so that's the end of my conclusion, but it is an open question. So now I think it's time to give the last word to Professor Andreone for closing the whole of this conference. Please.
Thank you so much, Professor, and I fully agree with you. So we should really think about saving the principle of common heritage of humankind and reflect on your words. Just to say that this is the very end of the 2 days, and that I am very happy because I tell myself that it seems a success because we discussed intensely, and now it's time to thank all people helping to the realization of this event, and the scientific committee, but also Federica Mandato, and thank you so much, and Paola Carratu, Monica Scala, Roberto Storchi, and Alfio Fallica. So thank you, and the 2 days recording will be published on our online channels. For the publication, you will be asked, the speaker will be asked if they want to publish their works, so keep in touch on this, and thank you very much, and have a safe travel back.